Good afternoon, this is Sean Golding with Golding & Golding, here to discuss a bit about renouncing your U.S. citizenship or terminating your long-term lawful permanent resident status. Typically in the beginning of the year, around tax season, we get lots of inquiries about renouncing citizenship, terminating a green card when they've had the green card for at least 8 of the past 15 years, whether it's for political purposes, whether it's for financial reasons. A lot of times taxpayers may get convinced to do something they ultimately wish they didn't do. Just buying some golden visas and your citizenship by investments and residency by investments and living offshore is not always as great as it sounds. So let's kind of dive in. So typically there's two categories of people who want to give up their citizenship or terminate their residence, okay? We're just going to use the term expatriate to refer to both. There are people who they have family in a foreign country. They were only in the U.S. temporarily, but it lasted longer than they thought. They're getting ready to retire. They don't need, their family lives overseas. They don't really have a reason to come to the U.S. much more than to visit. So there's no need to be subject to the worldwide income taxation, and therefore they want to renounce or terminate, expatriate. Alternatively, there are some people who want to go offshore because they think they're going to reduce their tax liability, and for some people they will. But many times, there's these shysters online that make it sound like you live this wonderful nomadic lifestyle overseas with not having to pay any tax because you have assets in one country, residence in another country, but it doesn't always work that way. Usually it doesn't. And so before those categories of individuals decide they want to expatriate, it's really important to understand the different components that are involved. Not that that's not important to someone who's giving up their citizenship or terminating for employment or retirement purposes, but for those people, that category of people, they have to, or they're planning on it. It's not just to reduce their tax rate. Okay, when it comes to renouncing citizenship, terminating permanent residence, I keep doing that, but let's just refer to expatriation, right? There's two components. There's immigration and then there's tax, right? From an immigration standpoint, typically if you're a green card holder, and when I mean green card holder, I mean long-term lawful permanent resident, which means you've had the green card for 8 of the past 15 years. It doesn't include years you made an 88-33 treaty election, and it doesn't have to be a full year, okay? 1 day in the first year, 1 day in the last year, 6 full years, you could still be subject to the expatriation exit tax rules as well. So from the immigration standpoint, you're renouncing your citizenship at the consulate or the embassy overseas. You're submitting your I-407 to terminate your green card. From the tax perspective, you are filing a Form 8854 in your final year. You're doing a dual status return, and then you may be subject to the exit tax. It all depends on whether a person is considered a covered expatriate. So, to take a step back, if you're a citizen, then you automatically have to do the 8854. If you're a green card holder, you had to be a long-term lawful permanent resident. Not all green card holders, right? If you do the 8854, which is your initial and annual expatriation statement, then you may be a covered expatriate, you may not. If you're not a covered expatriate, there's no exit tax. If you are a covered expatriate, you may be subject to the exit tax. In other words, just because you're a citizen or a long-term resident doesn't mean you're going to have to pay any exit tax when you renounce. Now, in order to be subject to the exit tax, right? Because that's the main component. The immigration typically isn't that bad. The main issue is whether they're going to be subject to exit tax, right? Of course, because who wants to pay tax just because you're leaving, you're giving up your status. It's covered expatriate, assuming the exceptions don't apply. The only main two exceptions are minor and dual citizen, but there's very specific nuances. It's not that simple. But those are the two main categories. So covered expatriate means your net worth is more than $2 million. Your net income average tax liability exceeds the threshold. I think it's around $190,000, $200,000. It varies each year depending on when you're listening to this. That adjusts for inflation. The net worth test historically has not adjusted for inflation. It's been $2 million for a while. With the net income average tax liability, something to keep in mind is it doesn't mean you earn the $200,000 a year. It means your net effective tax liability after tax credits, etc., were $200,000 averaged over 5 years. Okay, so there's sometimes ways to plan around it. If only one spouse is expatriating, you don't cut that, you don't slice it in half. You still use the full value of the return. And then the one that gets a lot of people, just because the IRS is horrible at explaining to people who are not U.S. persons by birth or who have foreign assets, accounts, investments, income about reporting and tax, is if they're not 5 years tax compliant. It could just be you didn't want to file returns because you didn't think you'd find yourself in this situation. It could be you misunderstood because your CPA got it wrong, your tax professional got it wrong. You didn't know you had to do these things. So if it's any one of these three, not all three. If either you meet the net worth test, you meet the net income average tax liability test, or you are not 5 years compliant at the time you expatriate, you could be considered a covered expatriate. Something to keep in mind as well. There's a distinction between when you file the tax return in the 8854, your final tax return in the 8854, which is the expatriation statement again, and when you actually renounce or terminate your status. If you terminate your status, let's say you go in and renounce before you've gotten into compliance, then you're posed with the problem of when you actually file your final tax return, which comes after in time you went in and renounced or terminated, well, now you could be considered a covered expatriate because you were not tax compliant at the time that you did that. So, speak with a specialist before you make any proactive representation to the IRS. With exit tax, it's not just the mark-to-market, which a lot of people think, oh, I don't have any stock, so I'm not going to be subject to an exit tax, right? You may be subject to an exit tax based on mark-to-market, although there is an exclusion amount, $800,000 and change, of that potential gain is not included in your exit tax calculation. But there's other things like specified tax-deferred accounts, for example, a traditional IRA. You might have ineligible deferred compensation, such as a foreign pension plan, although step-up value may apply. You may have eligible deferred compensation. Now, you typically don't get hit with the exit tax on that, like a 401k, assuming that you follow all the proper procedures. But at the time that you start receiving distributions, if you're covered, you might get hit with a tax liability, 30% for NRAs, non-resident aliens. At the time, that's what you'll be, presuming that you don't come back and become a U.S. person again, and you irrevocably waive the ability to make a treaty election to reduce the withholding. So it's a big deal. The reason I tell you all this is because lately we've been having people come to us who are only considering renouncing because they're thinking about living some offshore lifestyle where they don't have to pay any tax and they make a lot of money and they're not subject to any reporting or anything anywhere. It's not typically that easy. If you are going to expatriate and you're ready, and whether it's because you're going to retire, your family's overseas, or you want to live overseas and you think you're going to reduce your tax liability, it's important to plan first. Once you file the paperwork, you can't really unwind it and go back. So it's important that you do the research. There's a lot of information out there. We have a ton of free information available on our main website and our sub-websites. You can always reach out and schedule a reduced fee initial consultation if it's appropriate to your matter, and it's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.